And we have now HB 610 by Representative Landry.
Yes. Thank
Welcome
you.
to committee.
Thank you. HB 610, the short summary of it is it aims to assist minors who are victims of sexual assault in situations where the minor either may not have a parent or guardian, or the parent or guardian is the person accused of the assault. What this allows is it allows the minor to consent only to a forensic medical examination. This is an examination in a hospital performed by a SANE nurse under strict procedures that gathers evidence for a criminal investigation. Sometimes this may be a pelvic exam. Sometimes this may be scraping fingernails for evidence. This is only used to gather evidence for a potential criminal investigation later. There was some back and forth on the floor on this on the House side because some people didn't understand it. We worked through an amendment with Representative Bacala to include, even though this already happens, this includes specific information that DCFS is notified. As most of you know, SANE nurses have to notify, they're mandatory reporters when there's a case of abuse. So while this already happened, this language clarified that DCFS and law enforcement, I believe, would be notified. The bill ended up passing 100 yeas, 0 nays, and I believe it has 40 co-sponsors. I'm happy to answer any questions because it has gotten a little cloudy.
Yes, and just so everybody will know, we do have a technical amendment that you asked the committee to consider. Set number 2013, do you want to review that real quickly with the committee?
Yes, I did not print that. I'm sorry.
It basically says after examination, insert that notify a parent or guardian.
Yes, that was just a language. I believe it was mostly just a typo.
Okay, very good. Do we have any thoughts on that or any discussion? Seeing no discussion, I will offer up that amendment for Representative Landry. That's set number 2013. Do we have any opposition? Seeing no opposition, that amendment has been adopted to the bill.
Thank you.
Thank you very much. I see no questions right now at the present time. We do have cards of support. We have cards of opposition. And we do have Lauren with the DA's Association. So why don't we take right now cards of support, and we'll get in testimony of that. If anybody would wish to speak, we have Morgan Lamandra, Susan Nelson, and Will Harrell. No, Will says he supports it, but he does not want to speak. Morgan says she would like to speak, and Susan is here in support but not wishing to speak. So we have only one person in support that would like to speak, and Morgan, it's all yours. Welcome to committee.
Hi, thank you so much. My name is Morgan Lamandre. I am the legal director for STAR. It stands for Sexual Trauma Awareness and Response. We're a sexual assault organization, and we serve a good part of Louisiana. We have offices in Baton Rouge, New Orleans, and in Alexandria. So we cover a large portion of the population of, I guess, people needing our services. And we brought this bill asking Representative Landry to help us with sort of this problem we kept seeing, where the unfortunate truth is that many people can't even comprehend the fact that there are people out there who abuse their own children. And what we were seeing is people who, they have a child, either their boyfriend or somebody sexually assaults the child. Well, because taking that person to a hospital to collect forensic evidence, that evidence could be used against that person, they would come in and sort of object and say, no, I don't want you to perform this examination. With that being said, minors can consent to certain things already under the law. What was happening is that there were medical providers who had fears of conducting an exam in the face of a parent who was opposing, when in fact that parent was trying to protect the abuser or were the abuser. So ultimately law enforcement, DCFS would get out there, we can get this done, but because these examinations, the evidence is time sensitive, we wanted the medical providers to not really have fear of proceeding in that situation. The other thing is that we added the part about counseling because we had minors, believe it or not, there are minors who, despite all things that they're going through, they want counseling, but they don't have a parent just even in the picture. And the reason DCFS may not be be a guardian in that situation is because technically the child is safe, but even though they don't have like somebody who's bringing them to appointments and all. And I know that's very hard for some people to understand, but there are situations, and then as social workers or counselors, especially those that are working in the sexual assault centers, they can't currently provide counseling to someone without parental consent. So in these very specific situations where we saw this, we were hoping that that could happen. Now, our counselors are mandatory reporters. This always gets reported to law enforcement, DCFS. Same with the forensic examinations. But recently, and I just want to point out, this bill was pre-filed February 28th. And we have worked very hard with everyone who had concerns about, does this interfere with parental rights? Does this take away situations where parents have a right to, basically consent to certain types of medical care and treatment? Well, it doesn't, because in these situations where we're needing this, there is unfortunately no one in the picture. And, it's an unfortunate thing. It's hard for people to believe, but that's what's happening. And, it was pointed out some issues that there are with the bill. But I think we need to fix it. We don't just need to kill it, because right now we're just clarifying. Forensic examination is what we want to add, and we want to add the ability for counseling. Now, it was pointed out that the way we had it worded, and this was drafted by a staff attorney on the House side, it looked good, but like I said, it was pre-filed. We're only hearing about this today, that, hey, under Title 37, that could be a podiatrist giving counseling. Okay, well, the goal was for it to be like a licensed social worker or a licensed professional counselor. Let's change that. Let's not kill that. Obviously, our intent is not for there to be any issue. And then it's come to our attention that somehow this has something to do with abortion. That is absolutely incorrect. This has nothing to do with abortion. That's not even a factor in all this. These are people going to the hospital just trying to get help. This also comes into play for human trafficking, when there is literally no parent, there hasn't been a parent around because of just sort of the isolation in a long time. So, I mean, the child may get to the hospital through a sexual assault or some other factor because of the trafficking, and then in that moment, there ends up being a disclosure. And who are you going to ask for consent? The trafficker? I mean, it's concerning that the opposition, I just think that we should be able to work things out. And if there are things that we can figure out, and then we were working with some assistant district attorneys, and they had sent in some comments, and now I guess, it's unclear. At first I was going to explain who wrote this, but then there's concern about whether or not they should be coming to the table. And I know Mr. Lampert is here and he put in a white card, but I just want to read one statement from one of the prosecutors who is very much in support of this, but now is concerned about whether she can come right out and support it openly. But she put, as a prosecutor of child abuse cases, a forensic medical exam is a crucial puzzle piece to present to a jury in any viable child abuse prosecution. When such examination is not made available, possibly due to the actions of a manipulative parent or guardian or other actor, that puzzle piece and indeed the entire prosecution is put in jeopardy. Child abuse is a specialized area of the law, given that children are particularly vulnerable to not having their voices heard due to the actions of adults around them who may not have the child's best interest at heart and who may seek to cover up the abuse for various reasons. This bill, particularly with our suggested amendments, goes a long way to ensuring that children are able to tell their stories and get justice for their abuse. Furthermore, a cornerstone of this bill is that it does not in any way impair existing law on mandatory reporting of child abuse to ensure that appropriate investigations are conducted. Rather, this bill reaffirms and strengthens existing law on mandatory reporting by requiring notification to the Department of Children and Family Services and law enforcement if a forensic medical examination is conducted. So this is coming from a prosecutor. I'm happy to answer any questions, but I would just ask that once opposition comes up, we work through this.
Sure. The board is clear right now, and I would like to call right now probably two subject matter experts on it. DCFS, if you're here, we'd like to see if anybody here would like to come to the table.
And Senator
yes.
Mills, I don't know if I saw anybody from DCFS. They did testify on the House side and said that they can't support or oppose, but
Right.
they had no concerns with this
Some of the
bill.
committee members just wanted to ask him some questions. So
I'll try to get in contact.
Sure, we do have a question from Sen Barrow.
I have one question for you. During your testimony, you said the providers have a fear of proceeding to disclose any information. Can you speak more to that? What do you mean by that?
When you say disclose information, it's not that providers are having a fear of disclosing information. They're having a fear of performing the examination in the face of a guardian who is opposing, because guardians do have parental rights. And there was an attorney general opinion saying that ultimately, in the face of let's say a child who doesn't want certain medical treatment versus a parent who does, or vice versa, parents do have rights. But this is a little different, right? Because this is the collection of evidence that could implicate that parent or the person the parent is trying to protect. So when you have an objecting parent in front of you, that's the fear that they're going to have some sort of liability attached. Eventually, the providers can do these exams. It's just the longer time passes before the exam can happen, the more likely the evidence could be lost. It's lost if you go to the bathroom. So depending on situations, more time goes by, and that was these exams can ultimately be done. We were trying to cut the time that is lost, like the evidence that is lost in that process, to speed things up, basically.
Okay. Thank you, Mr. Chairman.
Thank you very much. So we'll call on Lauren Lampert to speak next, if you could, with the Louisiana District Attorneys Association.
Good afternoon, Mr. Chairman, members. Excuse me,
Welcome.
my voice is leaving me. Lauren Lampert, Executive Director, Louisiana District Attorneys Association. And we are here in the purest form of providing information. When our group looked at this bill, we thought it had more impact on the medical community than it did the criminal justice world, although they do synthesize pretty closely here. And so as such, we trust that the medical providers who have taken the oath to do no harm are going to look at this and do no harm. I think the questions that have surfaced are legitimate questions, and when you talk to a bunch of the prosecutors across the state that do this, they echo the problem that I think the author has mentioned, that many times the perpetrator is the person who is necessary to give consent. Or even if they're not, they're protecting the perpetrator because of some other relationship. And so there is something necessary. I think not having had the time to vet this through the normal process, there may be some better drafting that could be done. But in concept, I think generally prosecutors, and I can't speak for law enforcement professionals, but we understand the problem they're trying to solve, and it is a real problem. It's not a hammer looking for a nail. There is one. We do think the language, as she mentioned, I'm not a subject matter expert in this type of case, thank God, because it's special people that do these cases. They're tough cases to do. But I did reach out to some subject matter experts last night just to get some feedback and feel. And they were suggesting some language that might be tightened up, but I think the language that they suggested would run afoul of some of the amendments that brought on co-authors on the House side, and we really don't have the authority as an organization to seek that out and get in the middle of that. I do think one of the things that's missing that all people kind of agree should be there is that law enforcement should be notified as soon as practical under the circumstances as well. Although that's understood, it's not in the language as it currently exists. And I think, as I placed the amendment in, I think we cured that one defect that was found last night in the top part. So Beyond that, there are some jurisdictions that are going to believe this should be more broad because of the nature of the practice. There are other jurisdictions who should believe this should probably be tighter language because of the nature of the practice, local solutions to local problems. I believe what the author is trying to do is kind of hit the middle, which we understand that. So we're committed to help solve the problem, but we don't have any particular opposition other than we would like to see the terms law enforcement being notified as practical as possible under whatever the language was, as soon as practical under the circumstances, along with DCFS.
How do y'all read the last line on 17 that it kind of says this paragraph shall apply exclusively to cases in which there is a reasonable belief by the person? How do you define reasonable belief?
That is a legal term, and
this was Rep. Bacala's suggestion. I believe he's a former law enforcement officer. Is that correct?
He is, and it is obviously trained to law enforcement. Is there reasonable objective belief to develop probable cause, reasonable suspicion, all those things? It may not be a term of art that a medical provider would. But would
a medical provider understand what is reasonable belief?
That was my question. I don't know. I do think that they understand. If you talk to a medical provider, they understand when something's not right. How you define that in medical terms when something's not right, and I feel like I should be reporting. I think when you have under these circumstances where you have an underage child presenting with something that would lead them to believe a forensic medical exam is necessary or a SANE exam is necessary, a fortiori there's going to be reasonable belief I need to call the police. I mean, and obviously the age could factor there, but I would defer to this committee on that language because that is a medical issue more than a legal issue.
Right, and the medical board, I think he is here, maybe Dr. Collada's here, and he could add some clarity to that because I could see where a medical professional not trained in the training you guys have would really struggle with that language. Yes. We do have some questions, and is that you, Senator Mizell?
It would be great to have Dr. Collada for my question.
Okay, well, if Dr. Collada's in the overflow room, if you could come over. And I saw a button was punched, but it was between Senator Mizell and Luno. Did one of y'all want to speak? Or did y'all just hit a button by mistake? So nobody on this end?
I have no idea what his question is, and I can't even predict it.
No, he's very quiet. He's very calm right now. Senator Barrow?
Yes. Thank you, Mr. Chairman. So the bill was pre-filed back in February, and you guys didn't see it back then where you could have kind of weighed in. I'm a little concerned. First of all, very concerned about what happens with children. And this is, I know it's a very delicate position, of delicate place. But as you talked about trying to strike the right balance, sound like you didn't talk with the author until last night, or did y'all talk before? Or
quite, to be honest, we did review the bill, and we have this year's process of reviewing bills for everybody has been different, right?
I can understand that.
But our initial review was this is more of a medical issue than a legal issue. We actually reviewed the bill and we vote. We don't just jump into things willy nilly, and I'm not suggesting anybody does, but this was viewed by our board, the board that reviewed it of ADAs, that is more of a medical issue than it is a legal issue, that we would be white card kind of folks. We saw the amendments that were put on, and we heard the discussion on the House floor.
I didn't hear you say that before. Okay,
yes.
Go ahead.
But that's.
So once the amendments were put on, then you guys had more concerns, because initially when you reviewed it, you were okay with it.
I don't know that we had more concerns. I think it brought it. The discussion on the House side brought it solidly in the criminal justice arena, where before it was viewed more as a medical provider protection kind of thing. So, and so we were contacted last night just for information purposes, like, do you have any insight? So in response to that, to assist the committee, I reached out to some prosecutors who exist solely in this world, and those were just some of the comments that they made. And full disclosure, I actually put the author and Ms. Lamadre in touch with those folks directly, because I'm not probably the best one to filter through that information. So out of that, I think they had some amendments that everybody was happy with, but it would have required everybody to undo what was done on the House side, which for your purposes probably is not the right thing to do either. So does that make sense?
Yeah, it does make a lot of sense. And I think I understand what the intent of the author is in terms of what she's trying to accomplish. And I haven't heard from the opposition yet, but certainly as it relates to the well-being of kids and young people, this is something that I am extremely concerned about. And when we look at, I really would like to hear from DCFS because I'd like to know what that process is when a report is made. And then what kind of concerned me too, and I know that the young lady spoke to it in terms of the examination, the fear that providers have with the timing. I'm just trying to understand all those pieces and how they all correlate together.
And I think everybody is. And I think as we moves closer and closer to an investigative tool rather than a medical consent bill, it's brought to light some of those things. So I think what DCFS, I don't know what they would tell you, but I can tell you in my experience in 30 years as a police officer and a prosecutor, sometimes they're there immediately, sometimes they can't be. Same thing with law enforcement. Sometimes law enforcement gets there and discovers I was called by the Baton Rouge Police Department were called to Our Lady of the Lake, and we found out this happened in Zachary. So there's a lot of communication that has to go on there. I would suggest, and I would ask for when the medical folks come up, I do think it makes sense to me as a prosecutor and as a criminal justice professional, if you're going to do a forensic medical examination on a child, then you should notify DCFS and law enforcement, irrespective of what the reasonable belief is. If you as a medical provider believe that's the proper course of action and treatment, then necessarily it probably should be, that should trigger the notification immediately to law enforcement and DCFS. And then with respect to the others, I defer to the medical folks on that, but as we've been kind of brought into this discussion, those were just some of the concerns that came out.
Okay, thank you. Thank you so much.
Thank you.
Thank you, Mr. Chairman.
Thank you very much. Why don't we hear, if DCFS is here and the Board of Medical Examiners here, why don't we hear the informational piece next, and then we'll call in the opposition to testify. So I think, Representative, we may need the table.
Okay.
If you don't mind. I see Chip is here, or Chip has some representative here with DCFS, and we see Dr. Collada here. So let's get the informational purposes out, because I think Senator Mizell wanted Dr. Collada and you wanted DCFS. So let's hear that, and then we'll call opposition up and we'll talk some more. Well, we know y'all, but just state your name and we'll start the questioning. I tell you what, I think right now Senator Barrow has the floor, and then I'll turn it over to Senator Mizell and anybody else. So, any questions you may have for DCFS or the Board of Medical Examiners? They're here for you. You ready to go?
Well,
go ahead.
Go ahead, Chip. I was going to ask you, Mr. Coulter, in terms of the process with DCFS, in terms when a call is made, how this is actually done, the investigation piece. Seemingly, there's a question about the timing of when evidence can be, I guess, extracted, or the importance of not losing it. Can you speak more to that, or do you think we should do the medical side first?
Good afternoon, Senator Barrow.
I know you're trying to catch your breath too, huh?
Chip Coulter, Director of Criminal Affairs for DCFS, and apologize, we were in a meeting, and as I went into my office, I see the chairman ask for us, and so we made a quick dash over here. I would note that we have Mona Michelli from our program staff, who's probably 30 seconds behind me. Okay. Senator, if you don't mind, if we could allow one more question,
Mr. Chairman.
And she should be here after.
Sure, let's do that.
Thank you, Mr. Chairman.
Dr. Collada, you had a question for Dr. Collada? Senator Mizell. Okay, am I on your right mic? Because I don't know if you're on the right one. Are you on?
Can you hear me?
Try again.
Can you hear me now?
Yeah.
Yeah, okay. Thank you. Thank you, Mr. Chairman. I think I'd like to, I'm going to back up. I've been a CASA a long time before I had this job. And then I've been on the grand jury with children who have been assaulted on the cases of the grand jury. I've never even considered that there was an impediment to those children being examined by medical professionals because there didn't appear to be a problem in bringing them in as victims on the charges of the perpetrator, which in most cases had been the parent or the boyfriend, which we had talked about. So I'm trying to understand what would be happening now that could not be done without this bill. Where are the impediments you see now? Because I don't know how those situations happen if the medical professionals had not been allowed to examine the child in the past.
Vincent Collada, Executive Director of the Board of Medical Examiners, and maybe to get a view of this, we maybe have to look at the history. The legislature in its wisdom had modified the Children's Code many, many years ago to say that if a minor presented for complaints of pregnancy or pregnancy-related issues, sexually transmitted disease treatment, or contraception, they were deemed to be a major. So most of us have conducted that in that way for many, many years. However, occasionally some of the hospitals would say, we know that that's the law, but our policy, you still want to get the parents involved. So it kind of got a little muddled in some situations. Then with this bill, we're now talking about the issue of a forensic examination to be done because of a question of, was this child abuse, sexual trafficking, or some other such problem that's different from somebody just coming in and saying, I want to be treated for sexually transmitted disease. Now, I think the issue here is this is going to prevent what happens in a lot of emergency rooms where the doctor is well-meaning, well-intentioned, comes in to check the patient, even to do the exam himself, if he's trained to do the sexual examination for forensic purposes and collect the specimens and perform the collection of the rape kit and get it sent off in the proper chain of evidence. The parents begin to object, okay? And their objection is now being sometimes upheld by the doctor will say, okay, call a hospital attorney, and the hospital attorney will say, don't do it because the parents are objecting. Why was the patient here? Well, the patient was here because she said she was raped. Well, that's different than those three things we talked about earlier. So I think that this is going to serve to clarify and protect the child's ability to get that examination in a timely fashion. I had a great deal of concern earlier in this bill because I thought it was going to gut those three other provisions that we still operate under. But after seeing some of the amendments, it looks like that's going to protect those. And as long as it doesn't replace those other three, I think the rest of the issue is clearly one of getting these sexual forensic examinations done in a timely fashion and preventing what, is, look, it's often difficult to know who sometimes the perpetrator is and who's protecting who. But nonetheless, no matter who's the perpetrator, no matter who's protecting who, if this can be done without the parents' consent, I think it's going to be in the best interest of the children. I think that's what we want to do. Does that make, is that
well, it does, because I really wanted to understand better what we're currently doing. But, and maybe, and this probably isn't of interest on this bill, but it would help me understand a case like a shaken baby situation where the parent has abused the infant. What is the protocol there? I mean, can the parent say, I don't want this child examined, we're taking it home and stick to their story? Or can the doctor override the parent there without any legal support?
I'm not a pediatrician by trade. I want to make sure you understand that. And I didn't stay at a Hilton Inn last night. So I want you to know I have very limited expertise. But what I'm told by my pediatric colleagues is that in the shaken baby situation, they have a duty to call and ask for evaluation through DCFS or other agencies that would allow them to do it. Shaken baby is a little different than a 15 or 16-year-old woman who could be complaining of sexually transmitted disease and that kind of stuff.
Well, it would, but it's still, to me, the parent could still create an obstruction to bringing in the next level of assistance, whether it's DCFS or law enforcement.
Well, again, that's going to be DCFS and law enforcement are going to decide what the doctor should do in most of those cases. And if they need be, they can go get a court order. But again, I think the issue here is this particular situation is really not the same as the shaken baby.
Right. Yeah, I was just trying to, okay. Well, I appreciate your clearing that up.
Thank you, ma'am.
Just broke my mask.
Thank you very much, Senator. Dr. Collada, from your standpoint of, when physicians call you and say, okay, this law's just come out, how do I react to it? And you're in the board of giving guidance, or also if maybe you have to have some adjudication processes where maybe somebody violated their licensure. And I guess I'm getting back to that point where it says this paragraph shall apply exclusively to cases in which there is a reasonable belief. But now it affects current law that everything's a reasonable belief. So have we taken current law and it made it more complex for the medical provider?
Well, I think what it does, and we see this a lot of times, the medical provider, the physician may have talked to the child, the young woman, and decided that this really was something we need to not investigate because, and it's happened to me, 15-year-old comes in the office and is pregnant. I'm thinking, well, maybe this young girl was sexually assaulted. Turns out she had legal marriage certificate. Parents had signed up when she was legally married. But I think if the doctor determines that and the nurse feels like it should be done, you still have that situation where you could have both providers at odds, both trying to do the same thing, and it could paralyze the situation. So I think there are a lot of issues that are done, and we would look at each one of these, our investigative staff would look at each one of these individually. But in terms of reasonable belief, that's what the ordinary person would do, is what I'm told. And I think the key here is, what's the ordinary person going to think, and what's the ordinary person going to do? And I think those situations are going to be dictated by the uniqueness of each individual case at the time. As long as we don't got the ability of doctors to treat sexually transmitted disease, provide contraception, and treat for pregnancy, we'll be okay. I think the key here is we don't want to take out the old law and replace it with something that's not workable, and I don't think you have at this point in time.
Thank you for your expertise. I'm going to turn the floor over to Senator Barrow because I think she wanted to ask DCF some questions.
I do, but before I get to DCFS, I just want to kind of follow up with Dr. Collada. So, Dr. Collada, tell me this. So, as we're talking about minors, I want to go just to the definition of minor. When Senator Mizell brought up the shaken baby, that's a minor that cannot speak for themselves at all. So, for those who can, how does this apply? Because initially I was just thinking maybe 13, 18 or something. How would this apply to younger children? I mean, would this also apply to them in the whole scenario as it relates to reasonable belief and et cetera, in terms of how a physician provider would kind of move forward?
Well, I think that, we should never use a number to determine the degree with which somebody could be sexually assaulted.
Okay.
I think that's a fallacious argument, and I can tell you the youngest person that I ever personally delivered at Charity Hospital in my training was 11 years old. And I think that lady didn't get pregnant when she was 11. She got pregnant when she was 10.
That's right.
So I think we have to understand that these situations are unique to the individual, and I think it's also to the situation. And I think the ability to have the law say that they can consent in the face of a parent that says no is beneficial. And DCFS getting involved is beneficial. Because what you also have to understand is a lot of these children don't want to say anything. They just want to get treated for what they need to get treated for. And they don't want to ask questions. They answer questions. They are caught in the same kind of trap that some of the parents are caught in. Mm-hmm. And, the mother may be caught in a trap with an abusive sexual partner, consort, and then the child is going to be caught in that same trap, and they don't want to get there. I mean, you've seen abused children all the time that won't testify against their parents. Mm-hmm. So again, I think getting DCFS involved and getting this situation so that they can do the exams is important. And I just want to make sure we don't destroy the other portions of the child code that allow other things to take place.
Okay. All right. Thank you so much, Dr. Collada. Ms. Mona?
Yes. Hi, I'm Mona Michele with DCFS, and I'm available for any questions you may have.
So I want to understand how the process currently works, and I'm trying to look at the timing, because one of the things that I did hear that seemingly probably is the crux of the bill is the timing that it takes to do the examination, etc. But when you guys are called, or when you guys get involved, what happened? And I know things can be different, I guess, in metropolitan area versus a rural area, and how can this actually impact the ability for you guys to be able to proceed or have the evidence, I put it that way, that is necessary?
Okay, in terms of how we proceed, sometimes when we obtain a report that is called into the hotline, that forensic medical exam may have already occurred. So sometimes we receive the call after, and then sometimes we arrange for that medical exam and forensic interviewing after. I have not been able to read the amendments in its entirety, but in terms of the initial version, we did not have any, we are neutral, do not have any concerns with the impact to DCFS.
Okay. All right. Thank you.
Thank you very much, Madam Vice Chair. The board is clear, and now we call upon the opposition. We have Ms. Katie Cross has said she's present and she'd like to speak. She's with Louisiana Family Forum. And Ms. Liz Merles said she would like to speak also. She's with the Attorney General's office. And y'all have been very patient to wait, so we'll do a little house cleaning and then we'll be ready to go. Welcome to Health and Welfare.
Thank you, Mr. Chairman. I'm Liz Merle.
Welcome.
I'm with the Attorney General's office, and I'm here on behalf of the Attorney General. I think there's been some confusion relative to our position on this bill, and so I want to clarify that we have grave concerns about this bill. I think that it basically uses a sledgehammer to attack a nail. And it's just very broadly written. It has some very vague language that I think creates some significant problems with regard to who's doing this, what they're doing it, what they're doing, when they're doing it, where they're doing it, how they're doing it, why they're doing it, and it also affects reporting. So we already have been working on some of the mandatory reporting laws and trying to tighten those laws up. Senator Mizell has a bill related to that. I think is an important bill. I have very grave concerns about the fact that this bill has moved very, very quickly through a very short session. It wasn't dual referred to the criminal justice committees, but it deals with evidence. When we talk about a forensic exam, we're talking about evidence. And we're talking about the collection of evidence, and we're also now talking about medical professionals who are making decisions about whether something will or will not impede a criminal investigation. So I think there are just some problems. I'm not saying that the problem that was discussed here today isn't a problem that we may need to solve. I think that the law does address this consent problem already, and it may be that we just need to clarify what the law already permits, and that we don't need to change the law in a way that overlays law upon another law that creates more ambiguity and then creates more confusion about who is subject to who has to mandatory report, when they have to report, and what they have to report. So I do have some grave concerns about this bill. It does deal with a sensitive subject, and nobody wants to, least of all us. I mean, we're prosecutors too, and we certainly agree that we think that a child should be able to consent to obtain treatment and a forensic medical exam, and that sometimes parents are involved in that, and if that is a delicate situation that needs to be addressed, but I think the law already does address it, and so I'm concerned about a bill that has overbroad language and then also create some additional overbroad language about mandatory reporting. And it could do more harm than good. And so what I'm concerned about is the law of unintended consequences on a bill that even the DAs now agree has more criminal implications than criminal prosecutorial implications than what they originally thought. So I would ask that you defer this bill. I think that we need more time. If it's a problem, I'd like to see more stakeholder involvement and see the criminal justice folks be able to engage more. Prosecutors have differences of opinions on the language of this bill. So one prosecutor and sees it as potentially not broad enough, and one prosecutor sees it as as conflicting with a multidisciplinary process of dealing with child sexual assault that's covered by the Children's Code. So I just think these issues really need to be fully vetted, and because we all have concerns, we all want to protect children, but we don't want to do this in a way that harms them more than helps them.
Sen Luna, I see you have a question. Would you like to hear the opposition and then ask a question, or ask it now? Sure. All yours. Sen Luna for a question.
Mr. Merle, I hear your concerns, but it doesn't seem like to me that this is anything that can't be fixed with amendments to it. Have you met with the author or others and tried to do amendments to address your issues?
I expressed some concerns about the language of this bill, and then it somehow was communicated that the Attorney General's office supported this bill, and so I don't really know. I haven't talked to them today. I did express some concerns about the language that talks about a sexual assault counselor, which is not defined in the bill and doesn't cross-reference any definition anywhere else, and then licensed under Title 37, which it was me that said that could allow a person who basically does sexual assault training, who's a podiatrist, to do forensic exams. So these are the kind of concerns that I have.
Really think that a podiatrist is going to try to do that?
I mean, I don't, I'm just saying it's a problem with the language of the bill, and I understand that, they want to address a very specific problem. I'm happy to work on addressing that problem. The problem is that this bill moved very quickly through a very short session, and it hasn't had the proper stakeholder input.
Yeah,
so
we've done a lot of bills in a very short amount of time. I don't disagree with you on that. Yeah. I guess what I'm trying to figure out is, it sounds like to me every one of your concerns can be addressed with amendments. If this is the only issues you have, I don't know.
Senator Luna, I think the law already addresses this situation. So I think we fundamentally don't want to see another law layered on top of of laws that already address the situation, because that creates, as you know, I think as a lawyer, that will just create more ambiguity in the system.
Well, I'm told by the folks that contacted me about this bill that there is a gap, and there is a need for this.
There may be a gap in interpretation. That may not actually be a gap. We may be able to solve that problem with an Attorney General's opinion.
That's not what they were relaying to me. They were telling me that there's issues with a parent not allowing a child to be examined when the parent's the perpetrator.
But that's not, the law already permits the minor to give consent. What they are addressing is a doctor who is interpreting the law as not permitting him to do that exam. And I don't think the law does permit him to do that. If he's qualified to do it in a hospital. But this law seems to expand who can do it, where they can do it. It also has this whole counseling overlay, which I don't understand, which is not related to the forensic exam at all, really. So it's got two different moving parts. And both of those parts also relate to mandatory reporting, and they also talk about reporting as soon as practicable. I don't know what that means or when that occurs. And I have seen a problem with that with regard to abortion clinics and abortion doctors not reporting at all.
Don't we also already require doctors to do mandatory reporting, and they have to make interpretations of what these statutes are and what their requirements are?
Well, we do, and I don't. So this is, again, and I think that Mr. Kleinpeter addressed this issue too, that if you had a doctor and the parent was actively obstructing the doctor from doing a sexual assault exam that the minor was requesting and that the parent is opposing, that alone should be a trigger for the doctor to report to DCFS or to report to law enforcement or both immediately. Not as soon as is practicable. They should be calling the law enforcement in right then. So the language creates potentially delays in reporting or permits delays in reporting. these are the kinds of things that I call the law of unintended consequences. So I believe it is well intended. I think there are multiple problems with it, and because there are a lot of stakeholders here, I just don't think we have time to just get together and knock out some new language. I think we need to talk about it.
I think if we'd have been working on this already, we could have done that, but you may be right now. I don't know if we'll have enough time or not to take care of your concerns there, but I have to tell you, I don't share a lot of your concerns. I mean, I don't see it as being so wildly broad. I mean, there has to be a little bit of room for discretion and common sense when you're dealing with these situations. I mean, like Senator Mizell, I helped start the Rapides Children's Advocacy Center. I've been involved in these things for years. I understand these issues. I just don't see them the way you see them. And I'll tell you, I'm not a prosecutor. I've never, I've been a prosecutor before, but I never prosecuted anything like that. But the people that have done this tell me they need more tools in their toolbox, and this is one of them I think that could help them.
Well, I mean, and I understand. I don't think you want to give them a tool that's going to hurt more than it's going to help.
Okay. Thank you.
Thank you, Senator. Senator Ward?
Thank you. All right. I appreciate all the testimony. I think you said that it was already addressed in the law. Could you walk us through, not a situation, but like what would happen right now under the current law if something like this were to take place?
Well, I think a minor can obtain treatment and give consent to medical treatment especially for sex-related issues, sexual conduct, sexual diseases, those kinds of things specifically are covered by the law. So a minor can give consent and the doctor can do those things without notifying a parent under the current law. So I'm not sure where this disconnect has come, but I'm concerned that the language of this bill isn't really addressing that. It's so broad that, like I said, I think it's taken a sledgehammer to a nail. It's going to, I mean, we need to address a specific problem, and that is a gap in the law, then we need to address it with a rifle shot. We need to do it in a very clear and precise way that isn't going to impede the collection of evidence, conflict with potentially multidisciplinary counseling programs and things like that where you do collect evidence and you document things. I mean, this does involve investigatory procedures. It involves the collection of evidence. And so I just think we need to be very sensitive about how that's done and when it's done and make sure that all the I's are dotted and the T's are crossed. Because at the end of the day, it's going to affect the ability to protect that minor in the long run in the prosecutorial process and the criminal investigation process. And so I agree when they say evidence can be lost and it can be damaged. I mean, that is all absolutely correct. But that's what makes it important for us to get this right. And I just think that in the short session that we had a big recess where there wasn't very much communication about it. We didn't know what bills would be moving through the process at all. And now this bill is moving very, very quickly through the process, and it hasn't gone through criminal justice committees at all. And I'm sorry.
I certainly agree to you, but it seems like we as a legislature have picked and choose what we think is going to be properly vetted in this short time and what we think there's just not enough time to vet. And we use that for an excuse to kill some bills, and then we say, oh, we had plenty of time on the ones that we wanted to pass. But that's not directed at you. That's just more of a statement.
Yeah.
So I understand what you're saying because I've watched, not this in specific, but you just have to be so careful with these things. So that's what I'm trying to get to. What, if there is a gap, what could be done to close that gap? And I'm not saying that this is it or that this can be made to be it. I'm just asking, do you have any ideas on what could be done to close the gap?
Well, I mean, I think for one thing, I want to look at the system holistically, and I want to look at the different groups. I mean, just, reporting to law enforcement. So, for example, I think the district attorneys suggested we need to have specific reporting to law enforcement, but even that potential amendment needs to be more clear about what law enforcement is being, who do you report to and when do you report? I mean, right now the bill is vague about that, and it doesn't even require reporting to law enforcement. It's only to DCFS. And I can tell you, DCFS only investigates family related. They don't do an investigation if it's non-family related. So they may come in, and that decision gets complicated. Even their record keeping is limited. And I know this because I've done this work in my own cases. I've had to talk to them about what their process is. Their record keeping for reporting is 18 months. So if someone reports, now, first of all, we don't know when they're going to report because as soon as practicable isn't real clear. And then if it is reported, they're not going to keep that record very long. Their system's going to override it. And then the way they track documents is not the same as, say, law enforcement does. So we need to look at the system holistically, and we need to look at it with a reference of some specific cases where something has happened, and so that we're not just trying to kind of, address it with a shotgun that's going to create a whole bunch of other problems.
So it does warrant, or there is enough of a gap that we should at least take a hard study at it or look at what needs to be done?
Absolutely. I think if prosecutors are saying that they're having a problem, then we should address the problem. Not here to say that we shouldn't try and address the problem and address it with a good answer. I just think this is a very sensitive area, and it does have different moving parts, and it has medical involvement, it has evidence collection, investigatory people involved, and then it's got prosecutors involved, and it's got the mandatory reporting overlay and DCFS. So you got a lot of different actors, a lot of different pieces of this and ultimately at the heart of it, you have a victim who's a minor. And so we want to protect that person medically, psychologically, and criminal. I mean, with the prosecutorial process, we don't want to re-victimize them by messing it up. So I agree. We need to fix the problem. If there's a problem, we just need to not
thread the needle.
We need to thread the needle.
Thank you.
Real quick.
Question about President Pro Tem.
Real quick.
Oh, you can take your time. We good.
No, I've got to get to the house. I got a bill I'm worried about. I totally get what you're saying. I think we're all incredibly frustrated. And I find over and over we just start throwing things against the wall and hoping that something's going to solve the problem. And I know you've got the Louisiana law in front of you, but what do other states do that do it better than we do? What do other states do that thread that needle I mean, we continually try to create something that's working somewhere else and never really look all around us at what could be a better answer. So, I mean,
it's a good question. I don't have the answer for you right now. I can get that answer. I don't have it for you today. I'm not sure. I would have to go research the law of every state, or we can pull together some of the other subject matter experts who may have some knowledge of that and have that discussion. I think it's always good to look at what other states are doing and see if they have a good, crystal clear solution to language. Because language, I mean, that's the problem with the law, right? It's the language that really ultimately people get caught up on. They don't know what to do. They look to the law to figure out what they're supposed to do. And if the law's not clear, then we're not going to get clear results.
Well, yeah, but that I was hoping that we could find some solution that we knew worked somewhere else, because more than anything, I think the sweet spot is where it's working with medical and law enforcement for the good of the victim. Mm-hmm. And they can't be independent of one another. They've got to know that they're doing the right thing. And anyway, I appreciate what you've all had to say. Thank you, Mr. Chairman.
Very good questions. And we're going to get to you. We didn't forget you. Senator Barrow?
Yes, thank you so much. I was listening, trying to pay attention to everything going on. This bill it's really piqued my interest, and I'm trying to understand, and I guess connect the dots to some degree. So I heard you mention something about abortion, but I don't know if I heard all of what you said when you said that in the sentence. So can you repeat to me how that connects the ties to this bill?
The problem that I have encountered in some of the defense of our abortion laws is the failure to comply with mandatory reporting laws when a pregnant minor especially and particularly girls who are 11 and 12 years old and 13-year-olds. And Senator Mizell has a bill that's I think about to make it through the process that basically would make a child who's 13 the presumptive victim of abuse or neglect if she's pregnant, because there is some lack of clarity on children of that age who are pregnant. But even DCFS, in my conversations with them, agrees that a girl who's 13 who is pregnant, while she may not be the victim of rape, she is a victim of abuse or neglect. And so that should be reported. And it's not being reported. And the 11 and 12-year-olds aren't being reported, and yet those girls are victims of, per se, criminally defined first-degree rape. And those girls aren't being protected. So we have some problems with mandatory reporters, and we have some problems with the law not being entirely clear of who's supposed to be reporting, where they're supposed to report. And so I think we should address this problem. I think we need to look at it more holistically, and we need the medical personnel to be clear and understanding that they are mandatory reporters because they aren't complying, and I don't think this helps that. This only creates more problems with ambiguity in the law with regard to who's a mandatory reporter and when they're supposed to report and to whom.
And I think that was one of the big problems, that timing piece in terms of when the report is actually done, and how that information is actually retrieved. And I guess I'm so concerned because certainly I'm very aware of the abuse and the level of abuse that happens, how early it can actually happen, and how are we trying to make sure that we safeguard our children for me is the most important thing. I don't know. I guess I just listen a little bit more. Thank you very much.
I think that's obviously everybody's concerned about that. That's everyone's concern. We all share that same objective. So I'm not opposed to that, and that's not what our opposition is about. We're in favor of that.
Thank you, Mr. Chairman.
Thank you very much. And I have to say, the calls I've been getting, I haven't found anybody in opposition to the concept. It's basically, does this need to bake a little bit longer?
Yeah, it's the execution that's the problem, not the concept.
Yeah. I'm so sorry. You have been so patient and waiting. Please state your name and your thoughts.
Hi, I'm Christy Cross, and I'm here with Louisiana Family Forum on behalf of Gene Mills, our president, who regrets that he's not able to be here himself today. Louisiana Family Forum is firmly committed to addressing the concerns of minors who are sexual assault victims and or victims of exploitation or human trafficking. We've supported scores of bills that create protections for this insidious assault on Louisiana's children. I'm here today because we believe this bill needs more consideration than this compressed legislative session allows. Again, like Liz stated, the concept is good, but the details need to be worked out more. And this is unfortunately just come to light. It's not something that we could have addressed last week because we're just now finding out about it. There's a concern that the bill could even have the unintended consequence of impeding the prosecution of these perpetrators. More time is needed to determine whether this provision unintentionally protects the legal liability of counselors who may seek to keep the minor from the protections of the courts and law enforcement, as well as unintentionally impeding the investigation into those who purport to be boyfriends, but who may actually be abusers whose interest is to keep the family and the legal system in the dark. Thus far in the process, we've not opposed or supported the bill, but are now reevaluating. Our position on the bill was based on information provided to us that the bill does not erode parental rights or allow in any way the promotion of abortion. Based on that, we communicated with House members that the bill was not objectionable. We now understand that the information we originally received may have been inaccurate. No matter how well-intentioned the bill may be, we know that the bill may have serious consequences which need to be addressed before moving forward. There's not enough time left in this session to properly evaluate what those consequences might be. And again, to reiterate what Liz said, that there's concerns about whether the language in this bill could unintentionally give legal cover to counselors, even those that work at abortion facilities or organizations like Planned Parenthood, to to counsel and refer for abortion and thus not report the abuse of this minor. And at that point, all the evidence is gone. And what we're trying to do here in gathering the forensic evidence is actually not able to be done. So given these and the other factors that have been brought up today, we ask that you would defer reporting the bill until some of these questions can be evaluated. Thank you.
We appreciate you so much and everyone that's come here, because we said this last week and it kind of comes to light is, 38 senators said to defer health bills because it wasn't the time for people to be able to come to this Capitol and say what their thoughts are. And I appreciate every House member that has their bills here for the passion of it. But I think what you're echoing is a lot of calls that we're getting from constituents on a lot of bills is this is a condensed session. And if you have something that really is complex, maybe we ought to work on it a little bit more. But I appreciate your testimony.
Thank you.
And thank you, Ms. Merrill, for your testimony
Thank you
also.
for your time.
We appreciate y'all time. Representative Landry, would you like to come to close on your bill?
Yes.
Hi.
Thank you. Thank you for your patience.
Sorry for taking so much of your time.
No,
today.
this is an important issue, and you've done a lot of work on it.
It is. I'd like to address a couple things in my messy handwriting. First, to say that a bill should be deferred because this session was fast, I would agree with every single bill we've been here on. I think it's interesting when certain people use that argument to defer bills, and we've passed hundreds of substantial bills. So putting that aside, as Morgan said, this was filed on February 28th. I have never heard from the AG's office, not before the bill received 100 yes votes and 40 co-sponsors, or after. I don't know what miscommunication may have had there, but I have not heard from them. In thinking about this, I think there's been some movement in the background that I was not aware about regarding this bill, and at the suggestion of members of the committee, I would, and not because of the opposition, I would like to turn this into a study resolution. I actually was extremely pleasantly surprised last night when I heard that the district attorneys wanted to make this language broader and more encompassing, because this can be a very useful tool for law enforcement, and I would like to get it right with them to make sure that happens. And just to be clear, this has nothing to do with the opposition, which seemed to come from nowhere, and definitely no one reached out to me. So I really appreciate y'all listening to this. As I said at the beginning, this bill is designed specifically to assist minors who don't have anyone else to go to. And I think we all need to keep that in mind as we move through the process. Do you want to say something?
Very good. And we'll turn it over to Senator Barrow. One thing, though, if you are deferring, you might want to do an HR so it can just stay in the House and get out pretty quickly. Or maybe we can do an HR and an SR.
Is that, yeah.
We'll help you.
I'm new here, so
we'll help you with
the process.
We'll work with you.
Okay, thank you.
We'll work with you. Senator Barrow?
Yes, thank you, Mr. Chairman, and thank you for the bill. Certainly, I think I hear your heart and I know where you are, and I certainly care a lot about the well-being of children. Unfortunately, sometimes in this process, things don't always work out the way you intend them to, and sometimes the communication is not where it needs to be. But I encourage you to continue on. I think you're on a good path, and I think you're right. We need to get it right with law enforcement, because to hear someone say that it was too broad and someone say it's not narrow enough,
right.
That was very concerning. So I applaud you, and if there's any way I can assist you, I would be more than happy to do so.
I would appreciate reaching out to you, and like I said, to hear that law enforcement saw this as a positive thing, I think will only help.
We'll all work with you.
Thank you. I appreciate it.
So we have a motion by Senator Pope to defer HB 610. Is there any opposition? Seeing there is no opposition, it will be deferred, but we will work with you. And thank you for your testimony. You did a great job.
Thank you very much.